Right now, I want to bring in my legal panel. Here in the studio, I have with me to help me discuss former prosecutor and current criminal defense attorney Marsha Minot is here, and joining us from our New York studio, trial attorney Corey Stern is standing by. Corey and Marsha, thank you so much for being here. Have to ask you what you think of the state's decision to call Emanuela Postettini today. Did this move the ball forward for the state's case? Marsha.
I believe it was harmful to the state's case, and the reason I believe it was harmful is because her testimony was that the sexual encounters that she participated in with Miss Mann were not coerced, were not forced.
Right. Right. And then she owned the behavior afterwards. She owned the behavior. Yes, I sent him all these loving emails because I wanted to stay in touch with him for my career, to help my career. Corey, what do you think? Do you agree with Marsha?
I think that it could be seen that way, but it depends on the jury. And in fairness, the fact that she had a breakdown yesterday, Miss Mann, the fact that they heard her sobbing, this was a corroborating witness. There was nothing that she said that made the testimony from Miss Mann yesterday seem any less true. In fact, it likely made it seem more true. The veracity of what she talked about yesterday seems more likely to be believed. And so while on the one hand, yes, this witness's conduct and the way she described her own choices in contrast to the way Miss Mann described the choices or lack of choices that she made, yes, that juxtaposition might be difficult for a jury to really understand or to see. At the same time, everything that this witness testified to only corroborated the testimony from Ms. Mann from yesterday.
Well, and thank you, Corey. And the other thing here we have to be really cognizant of is it's only corroborating this incident that is not part of the instant case.
Correct.
That's where
it's not corroborating a crime,
Marsha. Right.
Because corroboration of a crime is what the state needs to get a conviction,
yes.
Not corroboration of sexual encounters or emotional breakdowns. And that's why I believe she's a better witness for the defense based on her testimony, especially since she was called out of turn. I think had she been called at the end of the testimony of this witness, then you might say, okay, I think it would be beneficial to the state. But there's something also in the law called primacy recency, where we remember the first thing and the last thing. She's in the middle.
Right, right. I mean, and certainly a strong witness. I mean, really, it seems to me like everything was very matter of fact, and she owned up to the behavior after the fact for what it's worth. But at the end of the day, they've got to prove the crimes they've charged.
It's not a crime for you to be emotional because you made bad choices.
Right, right. Marsha Minot, Corey Stern, so great to get both of your thoughts on all of this. We're going to talk more as Court TV Live continues. Have to take a break right now. When we come back, it is time for your daily sidebar, and we're going to talk about something that is an issue in every trial, and that is the credibility of the witnesses. And in particular, we're going to talk about Jessica Mann's testimony yesterday and how the jury will be assessing her credibility when they deliberate. Court TV Live continues after this break. I'm going to bring in now my legal panel here in the studio. Still with me, criminal defense attorney and former prosecutor Marsha Minot is here, and standing by in our Manhattan studio, trial attorney Corey Stern is with us. Corey and Marsha, thank you both so much. As we continue watching this case, I want to get your take on Jessica Mann's story. If we could go back to what she's saying and a conversation I had with Chanley Painter a short time ago, I think important point that was raised in our daily sidebar discussion was, did the alleged rape, or was the alleged rape the instance in which that was the first time there was intercourse between Harvey Weinstein and Jessica Mann? And that is what the jury's learned through the testimony. They've also learned that in 2014, there was intercourse again, and 2016 intercourse as well. And the prosecution is calling those instances non-coerced sexual encounters. That's how they're referring to them. So they're not part of the charged acts. Vinny made a great point. I thought he was saying, do you think that that's perhaps the line that was crossed for her when the intercourse happened the first time, either forcibly or not forcibly? The jury will make that determination. But Corey, as I understand it, you have experience in trying sex assault cases. Give me your thoughts on this timeline according to Jessica Mann.
So on the one hand, really all that matters is the incident which is at issue. And if a jury believes in that one particular incident that there was a rape that occurred, then nothing else should really matter. However, in real life, when we're talking to juries or dealing with juries or waiting while juries deliberate, The reality is that a jury is going to evaluate every bit of testimony, from what happened before the alleged rape to what happened during the incident where the alleged rape occurred to what happened subsequently thereafter, whether it was in 2014, 15, or 16. And so it's going to be very difficult for the prosecutor to not address all of those subsequent acts, despite the fact that that's really not what's at issue here. And the defense is doing a very, very, very good job of bringing up these subsequent incidents in an effort to sort of discredit the one incident that really matters here. But who knows, when you get in the back with the jury, or when the jury gets back there with each other, nobody has any idea whether they believe that this rape occurred and they're finding reasons to add credibility to what they believe, or if some of them believe there was never a rape and then they're finding reasons to convince the other jurors that it didn't occur.
Corey, thank you so much. Marcia, give me your thoughts on what she's laying out in terms of her story and, of course, the relationship that occurred prior to the incident in question and then the subsequent conduct thereafter.
Well, the issue you have is that it's vague right now. It's unclear as to whether or not there were other intercourse conduct that occurred between herself and the defendant that was consensual, and then she's now claiming except for the one on March 18th. Jurors are having to guess, and you're not allowed in a criminal trial to guess or draw inferences. You have to make your decision beyond a reasonable doubt based on the evidence, and that's the concern with this case at this point. I understand Vinny's point, and to his point is it's still vague, because no testimony has been provided, and that has not been clarified, neither by the state in direct examination or defense in cross-examination, that there's been any intercourse at all that was consensual.
Right. And I want to go back to the incident in question. The state has two crimes that are part of this indictment that are rape in the first degree and rape in the third degree, and they're listing Jessica Mann as the victim of these crimes. And they're saying they occurred on March 18th, 2013, and that third degree, to be clear, it's just a lesser included offense. This is all from one instance that's in question for the jury to decide whether it was a rape or not. But here's some of the facts that were testified to. She said she tried to leave that hotel room twice, and he shut the door both times on her. Then she said once she was on the bed with him, she tried to physically resist him on the bed as well, and he pushed her down on the bed. As far as verbally telling him no, that never happened. So she never verbally said anything, did not testify to screaming, did not try to call someone for help using the hotel phone, didn't pound on the wall of the room next door, didn't tell anyone, said that she was very, very embarrassed. And in fact, after this incident occurred, she went to a breakfast meeting with Harvey Weinstein and I believe one or two other folks to discuss some business. Has the prosecution met the elements they have to prove in order to establish this rape took place? Corey, what do you think?
Absolutely. I mean, you don't have to say no to give the impression that it's a no. I mean, you're asking a lot of a victim in this particular situation when you're requiring them to use certain specific words in order to show that they're not agreeing to participate in a sex act. I mean, this is 2020. You know, there's women who have come forward for years and years and years and years who have described their body language, who have described the way they reacted. And I think it's putting a lot on a very young woman or any woman of any age to insist that she say no in order to say no. Sometimes we say things, I mean, I say things every day without opening my mouth. My kids know when I'm mad without me telling them I'm mad. My wife knows when I'm sorry without me necessarily apologizing. And in the course of a crime or in an alleged crime, if we insist in 2020 that a woman says very specific words in order for no to be said, then we're asking a ton from victims, especially when they're dealing with a perpetrator who has so much power over them.
Appreciate your thoughts on that, Corey. Marcia, do you agree?
Well, not necessarily, because facts cannot be looked at in a vacuum. The totality of the circumstances has to be considered, and that's why it's imperative that we look at evidence of conduct subsequent to the alleged rape, because you can always have buyer's remorse if the relationship that you are in did not work out the way you thought it should have. You didn't get the career advances that you were looking for, and I agree that you don't have to have a victim say, or an alleged victim say, no, outright no, that if you don't hear those words, that it would not have been a rape. But it's the subsequent conduct of not sharing it with anyone, not making the outcry even after you've left the environment because you were concerned for your safety at the time, and that you are now free, and then to be reaching out and making contact with your alleged abuser is where the totality of the circumstances come in to say, well, wait just a second.
Right. I appreciate those thoughts, Marcia. And the totality, I think, is really key here, because what's at issue is consent. Did he know by the body language, by the dynamic in the room, that she didn't want to participate in this? Because through her own testimony, she was in a relationship with him at this time, and he was doing degrading things like urinating on her as part of their physical intimacy in this relationship. So I think we can't look at it as what one of us might have done if in the same situation. This has to be objectively, what a reasonable person in this position, the law is objective, what a reasonable person in this position have understood it, to be spoken in that way.
Yeah, the concern too is that the corroborating witness testified that there was a situation where she left the room, and even the testimony from the corroborating witness was that he was alarmed. What's going on with her? He was questioning, why is she behaving in that manner? The testimony wasn't that he was angry or that he tried to grab after her or he chased after her. So when you put that testimony into context based on the conduct afterwards and the reaching out to the alleged victim, I don't know if the state has met their burden.
Right. This case is certainly not a slam dunk for either side. And Marcia and Corey, you both know this. This is why cases like this go to trial, because it's very, very unclear factually what may have occurred in these instances. Corey and Marcia, thank you both so much. We have to step aside, take a break right now. When we come back, we'll bring you much more testimony from the courtroom in the state of New York versus defendant Harvey Weinstein.
Tonight on Court TV.
The jury in the Harvey Weinstein rape trial has seen day after day of gripping testimony and shocking disclosures. But have prosecutors built a strong enough case to convict?
All right, I'm going to bring in now my legal panel to discuss her testimony some more. Marcia Minot still in the studio with me, and Corey Stern is in our Manhattan studio. Okay, let's talk about what Julia told us that may have come as a surprise to some on the jury, that we learned through this cross-examination that Jessica Mann was still in this relationship with Harvey Weinstein, having another sexual encounter at some point in 2017. She couldn't recall if it was either February or November, but in either case, in the year 2017. And it's really unclear when and how it ended. We know that Harvey Weinstein became a big focus in the fall of 2017 with all the other accusations and the Me Too movement. How does this help or hurt the case? Marcia, what do you think?
Well, it begs the question if the relationship ended because the Me Too movement came about and the allegations started surfacing. And that's something we will never know because we cannot rewrite history. So there are concerns about whether or not she actually ended the relationship, or the Me Too movement ended the relationship, or the allegations ended the relationship. In closing, as the defense, you want to argue the state has the burden. You can't fill the gaps. You cannot create evidence. If the evidence is not given to you by this prosecution, then it's reasonable doubt and our client has to be found not guilty.
Right.
If I'm the state, then I'd be arguing, look, it ended because now she was brave enough because other women were making outcries.
Yes.
And she no longer had to worry about the vendetta or the vindictiveness because she had company, other corroborating victims.
Exactly. Marcia, appreciate that. Corey, give us your thoughts, please.
Again, I think that every juror at some point has probably already made up his or her mind in terms of who they believe. And ultimately, the arguments that are made in closing about those gaps that can't be filled or should not be filled by evidence that doesn't exist, jurors tend to fill those gaps themselves based on the tendencies and leanings that they have going into that jury room. And so it's very hard to speculate today about what all of this means in terms of when the relationship ended, and more importantly, how jurors view why the relationship ended. Because if I'm a juror who believes that she was raped, I believe the prosecution side, where perhaps the Me Too movement gave her license to end the relationship, gave her the strength to end the relationship. Whereas if I'm leaning towards the defense strongly or even lightly, I might want to believe that the only reason that she came forward is out of embarrassment because of the Me Too movement. And that is supported in many ways by the email that she sent, which was read, as well as the second email to the company that's like a self-help group.
Corey Stern, trial attorney, thank you for joining us from New York City throughout the show. And Marcia Minot, a former prosecutor, criminal defense attorney. Always great to have you in our studio here at Court TV. Thank you both so much, lending us your expertise. We're going to step aside now, take a break. I want to give you a special programming note as we do that. Tonight,